So as you may have already heard, the 7th Circuit Court of Appeals, that's one based out of Chicago, has ruled that short-barreled rifles, SBRs, are not arms protected by the Second Amendment. We're going to be going through quickly that decision as well as contextualizing it in the history of course, the United States Supreme Court, specifically looking at the Miller decision. Bottom line, what does this all mean in English, both now and moving forward in the future? Guys, let's get into it. So here's the deal. Mr. Jamond Rush got nabbed in 2022 for possessing an unregistered Anderson Arms AR15 with a 7.5-inch barrel. That's a short barrel rifle thanks to the National Firearms Act, otherwise known as the NFA. Now this happened, I believe it was in the Southern District of Illinois. Now for those of you who may not be aware, possession of short barrel rifles is not ordinary in Illinois. This is not something that you can just go out and purchase, much like it isn't in really any state. In most states where it is legal, which is most states, you have to go out and go through the ATF. You got to get your Form 1, Form 4, pay a $200 tax stamp, wait, all that kind of stuff. In Illinois, you still have to do that, but you also have to have a curio and relic license. You have to have a C&R license. So they continue to burden this. That's going to be important, but we're going to get to it in a little bit, so put a pin in that. So the National Firearms Act, we're dealing with Section 5861 sub D. That's right, 5861 sub D. I know you love it. I know you know it. That's the one that basically says that you cannot have certain firearms like SBRs unless they are registered with the ATF. And of course, the ATF will not allow you to register it if it is not in compliance with state law. Now, Mr. Rush was indicted. He pled guilty after losing a trial court motion level, but with the condition that he wanted to challenge the law's constitutionality. And then, of course, he got promptly slapped with 30 months in prison. So about 2.5 years. So he appealed, arguing that after the 2022 Bruen decision that the National Firearms Act law violates his Second Amendment rights as it pertains to short barrel rifle possession. The district court, that's the federal trial court level, as I already mentioned before, wasn't buying it, saying, and I quote, Bruen had no impact on the constitutionality of regulating unregistered short barrel rifles. Now, Rush's challenge was a big one, big uphill climb. It's what we call a facial challenge under the law, meaning that he had to prove that there's no situation where this law could be construed as valid. That's a tough hill to climb, legally speaking, and the court shot it down ultimately. Why? Well, they wound up leaning awfully hard on the 1939 Supreme Court case, specifically United States versus Miller, and said that in brief, it still controls. Now, if you've been around the channel, you know United States versus Miller. We've got 3 videos on this, all linked below in the description box as well as in the pinned comment. One on its absolutely wild backstory. We're talking about the fact that the defense counsel was not present at the Supreme Court ruling. In other words, only the anti-gun government was there arguing. Defense counsel didn't even get the briefing until days before the oral arguments. I mean, it's a wild backstory. Check out the video. Another video on its modern impact, which is to say, how has it been baptized and how does it live and coexist in the Second Amendment ecosphere of cases as it exists right now? And a third one where literally I go through and just read it all for you. If you're like me, I like consuming books and content on tape as I'm driving places and doing things, and I figured, well, if I'm strange and I like doing this, maybe you're strange and you like doing this as well. So I've started to kind of put books on tape, except we're talking about Second Amendment Supreme Court cases. Now, if you don't know, in a nutshell, Miller dealt with 2 guys caught with an unregistered short barrel shotgun, an SBS. The Supreme Court said that the Second Amendment's point is to ensure a well-regulated militia can defend the nation. They looked at the short barrel shotgun and basically said, hey, the military doesn't use these as standard gear and equipment. So, as a result, short barrel shotguns not protected. Simple math, no militia tie, no Second Amendment violation when it comes to the restrictions against them under law. Now, fast forward to 2008. Now we're talking about DC versus Heller. Justice Scalia took the Miller case and gave it a bit of a twist. He said the issue wasn't that the defendants had a gun outside military use. It was the type of gun. quote, in the absence of any evidence that possession or use of short-barrel shotgun has some reasonable relationship to a well-regulated militia, we cannot say the Second Amendment guarantees the right to keep and bear such an instrument. That such an instrument part, that's Scalia saying that not every weapon gets a free pass. Again, don't get angry at me, I'm just the messenger. Scalia basically bit into the idea that the Second Amendment only protects National Guard stuff. In other words, he didn't like that idea. He didn't like the direction that was going in. And Scalia talked about the fact that, look, if we interpret Miller in this way, as I know a lot of people in gun forums do, again, don't shoot the messenger, I'm just going into what the Supreme Court has said, that Miller could be used to justify owning rocket-propelled grenades, which is legal under, DD, NFA, but that's neither here or there, but you get the idea. In a nutshell, Scalia didn't like the direction that Miller was kind of under that reading pointing in, that only weapons used in the military were protected by the Second Amendment. So instead, he kind of baptizes it into this tradition. Much deeper dive in those videos. Check it out. I'm not going to dwell on it here too much. So Heller, in essence, attempts to redefine Miller to protect weapons that are in common use for lawful purposes, such as self-defense. All right, so now back to Mr. Rush. The Seventh Circuit, led by Judge Joshua Kolar, who, by the way, is, of course, a President Biden appointee, reviewed this case de novo. That means fresh eyes, theoretically no bias, everything set to zero. The three-judge panel asked, is Section 5861 sub D constitutional on its face? Of course, Mr. Rush said no, pointing to Bruen, which set a two-step test for gun laws. Now, step one is, again, low resolution this. Does the Second Amendment text cover the conduct, which in this case, we're talking about owning a short-barrel rifle? Step two is, if it does cover the conduct, is the regulation historically fine? In other words, does it fit within the nation's historical tradition of regulating firearms? And to do so, we're talking about needing a historical analog, not a historical twin. The court stopped at the first step. And they said, look, SBRs are not arms under the Second Amendment because they're not typically used by law-abiding folks for self-defense. Which, of course, if you think about it, is a ginormous bit of circular reasoning, because if you basically ban a weapon and then the places where it's not banned, you burden it with a crazy process, a crazy procedure that requires an enormous amount of understanding, paperwork, sophistication, not to mention a $200 fee. Guess what? There's going to be way less people going through all that compared to things that you don't put in that fee. So we've got a massive circular reasoning that the government has set up where they say, in essence, hey, this particular set of firearms that we set up back in 1934, you can't possess these unless you pay a whole bunch of extra money and go through this really difficult series of steps. And then, of course, flash forward about 90 years later where they say, turns out a lot of people don't have these firearms. We're going to determine that despite the fact that I think from memory, there's over 500,000, 521,000 or something in circulation, that's not common enough for lawful purposes such as self-defense. Yes, I know. I'll spare you the headache. That's the circular reasoning the government has set up. Just the same, the circuit court leaned on Miller, Heller, and their own 2023 case, Beavis versus City of Naperville, that we've covered here before, which basically said the same thing about all this kind of stuff. So bottom line, they are ruling it is not an arm for purposes of Second Amendment. It is not protected by the Second Amendment. So then we get to step two. Even if SBRs were protected, which they said they weren't, the National Firearms Act registration and tax rules match historical traditions. In other words, they're saying, look, even if it is protected, you still lose because the NFA passes historical muster. Again, not me saying this. Cannot stress that enough. The government dug up a bunch of old laws like the 1649 Massachusetts rule on musket length. I think that where they said it cannot be less than about 3 feet in length. They also look at Virginia's 1785 militia firearms specs, as well as colonial registration laws, which there are a few. They even cited, quote, going armed, end quote, prohibitions from English common law aimed at dangerous concealable weapons. The court agreed that the National Firearms Act, why, namely the attempt to stop criminals from using, as well as the how, registration, and the fact that In the court's views, this was not a ban. This is simply setting up a registration. This all is enough to pass this step 2, even if it got there, which it didn't, but even if it got there, the historical tradition test. And again, Rush once more argued here that SBRs are common today. And here actually I have the number. So before I was guessing, this is the number as of 2021, 532,725, 532,725, if you had that on your bingo card, registered SBRs as of 2021. But guess what? The court conveniently says, you know what? Numbers don't matter without a lawful purpose. Because obviously, all 532,725 registered SBRs, they don't have a lawful purpose. They're not using them for anything lawful, must be the court's argument and reasoning, because they're saying, look, you have to have a lawful purpose for possession, which probably goes back to what Mr. Rush was up to at the time, but we're sidestepping that for the time being. Now, if you're wondering about what's been going on around the nation, because if you've been following things, you know that the 7th Circuit Court of Appeals is no friend to the Second Amendment. So when I saw 7th Circuit SBR Second Amendment case, I knew what was going to be the outcome because I've never seen them argue or rule anything pro-Second Amendment. So I was doing a search around just to try to update you all on what else is out there. I got 2 federal district court cases. These are federal trial courts, so they're not of any precedential value. One is Watterson versus Garland. That's the Eastern District of Texas from 2024, as well as United States versus Chan. That's Hawaii 2024. Both ruled that short barrel rifles are not protected arms, effectively parodying Miller's not in common use for lawful purposes line. What's the bottom line and where all this is going? I've said it before and I'll say it again. I'm not particularly bullish, which is to say I'm not particularly optimistic on where I think things like machine guns and below that short barrel rifles might be going when it comes to a constitutionality test future. Why? Well, for instance, in both Heller and Bruen, we're dealing with the fact that, well, in Heller, Scalia said that ordinary people do have a right to bear arms, which of course was backed up in Bruen. And then it goes on to discuss the fact that ordinary weapons in common use, such as handguns, are good to go, but not machine guns. He called it startling to think that Miller protects military gear and equipment like machine guns, that's Scalia, since that would unravel the National Firearms Act, in essence. Again, this is low resolution, much more higher resolution take in those videos linked down below. Bruen doubled down in 2022, cementing this common use for self-defense standard or common use for lawful purposes such as self-defense standard. I don't want to be the bearer of bad news. This is not stating my own personal belief. This is me stating what I think the courts will eventually rule at the end of the day. Machine guns, bad, although there have been a couple courts that have thrown out machine guns. So that's interesting if you want me to go into that. And I think SBRs are going to be iffy, but leaning towards bad, as in dangerous and unusual. And I'm really interested to see what happens with suppressors. There's been a recent court case that basically said that suppressors are likewise not an arm, therefore they're not protected by the Second Amendment, which is curious because they are, of course, regulated as being a firearm thanks to federal statute. But hey, we've talked about this before. Suppressors get the worst of it at both ends. They're treated like firearms when it comes to criminal law, but they don't get Second Amendment protections when it comes to courts. Talk about having your cake and eating it too if you're an anti-gunner. We're going to close out with our ever popular quote of the day. I appreciate you sticking around this long. If you don't mind, please consider hitting that like button. Drop a comment down below to let me know what you think about all this. This quote comes from the Roman thinker, philosopher, writer, Cicero. Quote, "To be ignorant of what occurred before you were born is to remain always a child." Again, I appreciate you tuning in, and I'll see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.